Welcome everybody to Constitution Day 2022. It's our first Constitution Day in person since the pandemic, and so it's a delight to be here once again. Today we're going to talk a little bit about Constitution Day, and then I'll introduce our panelists, and then we'll engage in a little bit of conversation about the First Amendment by each opening up with presentations and then opening it up to questions for all of you. So let me begin by giving a little bit of a background about Constitution Day. The Constitution Day was established as a federal holiday, and one of the requirements of every university in the United States that receives federal funding is to hold an event in observance of Constitution Day annually on September 17th. And whenever Constitution Day falls on a weekend, then you can observe Constitution Day either on the Friday or the Monday before and after that particular weekend. And so here we are on Monday, September 19th, celebrating Constitution Day. If we did not do Constitution Day and we did not observe Constitution Day, then the federal funding that helps pay for a lot of your services here at the university would not be made available to us. And so it's a significant event, both by mandate, but also because as a constitutional scholar, I think that it's important for us to learn about First Amendment issues as a First Amendment researcher and constitutional issues more generally. And so every single year, the Center for First Amendment Studies makes sure that the university is in compliance with the federal mandate for Constitution Day. Okay, so that's the background of this particular day. Joining us today are Dr. Jason Whitehead. He's an associate professor in the Department of Political Science. He's also the director of the Legal Studies certificate here on campus, and he has both a PhD and a JD, and so he's fancy. And then also joining us is Amy Yamasaki. She's a graduate student and research fellow for the Center for First Amendment Studies, and she's on the panel to share with you some observations as a future budding scholar in constitutional issues and as a student herself, and so to gain a student perspective on the panel. So thank you so much for joining us. Can we give them a round of applause? Yeah. I'd like to begin today, before I then allow these two panelists to open up with their opening remarks, by giving a little bit of a background of the Constitution and my particular perspective. The Constitution, starting with Marbury versus Madison, basically became a place where the Supreme Court was the institution that would settle most of the matters when it came to constitutional interpretation. I've always found the constitutional interpretation to be rather interesting. There's a famous scholar by the name of Philip Bobbitt. Philip Bobbitt was a constitutional scholar, and he introduced what are called interpretive or constitutional modalities by way of how we interpret this document. So if you take a look at any legal document, especially a constitution, there's written into the Constitution certain words that need to be defined, and those things that are defined are based on concrete events and things that happen. Rights are not abstract things, right? They involve particular cases that are then contested to note, is this your right or is this not your right? And so we have to define in that moment if it's your right or not, right? And so we have a bunch of modalities that different people use when they're interpreting the Constitution. Some people disagree with each other entirely with how we should interpret the Constitution. So what Professor Bobbitt does is that he outlines 6 different modalities of interpretation, which I find particularly fascinating. Traditionally, we like to think about the Supreme Court as an ideological court, right? And most recently, we've had abortion decisions that have been decided 6-3 that look extremely ideological. We have other opinions throughout our history that are 5-4, like Bush versus Gore, which was a significant decision that impacted our electoral winner in that election. And what most people don't realize that are not constitutional scholars is that so many times these decisions are really based on the nuances of these modalities than they are based on strict conservative ideological orientations. So it's not as easy as saying, I'm a Republican justice and therefore I vote for Republican things. Or I'm a Democrat justice and therefore I vote for liberal things. That's not how the court works in practice. Most significantly, even in the case that I just mentioned, Bush v. Gore, it was a 5-4 opinion. Justice Souter was in the minority of that particular decision, ruled against George W. Bush in that particular decision. And he was appointed by George H.W. Bush to be a Supreme Court justice. So even an ideological kind of decision like that we assume is a 5-4 split, most people thought that those 5-4 opinions, the 4 justices, were in the minority, liberal-oriented viewpoint, when in fact you had Justice Souter, who was an H.W. Bush appointee, and Justice Stevens, who was a Gerald Ford appointee, both Republican appointees at the time. So it's not as easy to get at that. How do you account for the fact that Justice Scalia and Justice Thomas disagree in cases like Brown versus Entertainment Merchants Association? If it were so easy to just say ideology explains how the court makes its decisions, then it would be easy to apply that to those kinds of cases and say it makes perfect sense, right? But we know as constitutional scholars that interpretation doesn't work that way. So Bobbitt says that there are 6 different ways and combinations of interpretation that people use when they're interpreting a constitutional text. For example, he says that history is one. To find out what the meaning of free speech meant, you look back to what free speech meant when people decided that you had the freedom of speech. You define it historically. How did the framers, how did the founders, how did they define free speech? Such an interpreter might say, wow, that's very interesting that you think you should be able to communicate on your computers, but computer communication was nothing considered by free speech. If we want to debate those things in our democracy, we can have computer rights, but until we have those debates, it's not in the Constitution, right? And so as a matter of the Constitution, it's not protected by free speech. Free speech meant speaking in public forums and so forth. That's what was happening at the time of the founding era, right? The second modality is text. A textual interpretation might take a look at what most people might understand the word to mean, or what the dictionary might define it to be. So you might look at Webster's dictionary to see freedom of speech. It means speaking, right? If you signed up for a public speaking course and all they taught you was how to use a computer, you'd probably be pretty disappointed, right? And so that person who's interpreting the text would say freedom of speech doesn't include computers because speech doesn't mean computers, right? It's written, it's typed, it's something else. Maybe freedom of press, right? Because journalists do their work on computers, but it's not freedom of speech in the textual sense, right? So they might take a look at what that word means in that particular dictionary kind of definition. Or they might take a look and say, on the third interpretation might be on a doctrinal or precedent, right? What has the court decided that these things mean, right? If the court has defined already that computers are protected speech, then we're going to go along with that precedent because the court is the one that should define these particular terms to adapt in our living democracy. It shouldn't be going back to the framers and so forth, right? And so those are 3. A fourth one is based on a prudential modality, right? A prudential modality might say, was it prudent? Was it practical? What is going to be the result of my particular decision? If I define free speech as involving computers, then all these people over here, millions of people are going to file lawsuits tomorrow because they believe that their free speech rights were infringed, and the courts aren't going to be able to handle it. It's not a prudent type of decision. So they might define free speech as being computers, but only from this day moving forward. And then they define it kind of that way, right? And so they're figuring out whether there are pragmatic structures in place, right? Prudent structures. The fifth type of modality involves a structural modality. It involves needing to define things based on competing clauses. An easy example of this is you have the freedom of assembly, but do you have the freedom to assemble in front of a voting booth in a way that would prevent other people from voting, right? If people are assembling and people can't enter a voting booth, then you're infringing on their freedom of vote, right? The right to vote. And so the court might define freedom of speech, yes, but that also means not infringing on the right to vote. Or freedom of assembly, yes, but that doesn't infringe on the right to vote. And so they define freedom of speech and freedom of assembly different based on the way that they give privilege to maybe another right, and trying to structurally work through these inconsistencies that require new definitions in some kinds of cases, right? And then the last modality that he talks about is the ethical modality. And this is based on the idea that democracy matures in the constitutional text, that it's written rather vague at the origins, and it's up to us to be able to determine the meaning for it to work today, based on the lessons that we've learned of the past. And so just as an infant doesn't know everything about their life, neither did our beginning democracy. And so built into the Constitution is this ethical value system, right? Yeah, freedom of speech might not be explicitly computers, but there's a value there, right? Getting your information out, getting your voice out, etc. And so therefore, computers may be considered freedom of speech and defined as freedom of speech within that modality. Now, what makes constitutional interpretation so complicated is that every single justice on the court actually has a hybrid view of this, right? So some justices might privilege history over doctrine. Some may privilege doctrine over history. Some may privilege text over ethics. Some may privilege ethics over prudence, right? So there's a lot of nuances that then result to reflect Supreme Court decisions that I think, in my own scholarship, come to influence the way that we think about the Constitution today, and that reflect a lot of the nuances in the court. Because another random fact is that the court and the interpretation is much less ideological than most people think. The most common opinion, the most frequently occurring opinion, the mode, if you will, for you statisticians, okay? The mode is a 9-0 decision. That's the most common decision. The most common decision of the court is a 9-0. So it's kind of strange then that we think about it as functioning in this kind of ideological way all the time as a good rubric. Now, is that to say that the ideological metric is flawed? No, it's just not as precise, right? One can speak of a conservatively oriented justice because they tend to interpret the Constitution more in line with history and text, right? One can speak of liberally oriented justice because they tend to consider the ethical interpretation more often, right? So the perspective can sometimes highlight the differences in the nuances, I think, more precise than the conservative and liberal split, even as they're bound to more nuance than that. I would also like to say that this marks an interesting era of the Supreme Court. One of the things that I reflected on recently is that, at least in my knowledge, and maybe Professor Whitehead will be able to note, I don't know if Amy has quite studied these things yet, but it's the first time that I can remember a court where there's members on the court, plural, like at least 2 members, that skip an entire presidency, right? So we have George W. Bush, who has both Justice Alito and Chief Justice Roberts on the court, and we have a George H.W. Bush appointee with Justice Thomas, right? So in between the George H.W. presidency and the George W. Bush presidency is President Clinton, and we have no justices from that 8-year era. And I find that particularly fascinating. The results are quite obvious, right? We recently had 3 appointees that the Trump administration would be able to get. We have certain decisions that liberally oriented people consider a scale back from the rights that have been so hardly fought for in Roe v. Wade and gun control kinds of decisions and so forth and so on. So there is perhaps little doubt that the makeup and attitude of the court has shifted. How much, I think that we'll probably discuss today, because some of those decisions may have been handed down even if it was a 5-4 opinion, considering that the liberal-oriented court hasn't been a thing for quite some time. So with that said, I'll introduce Professor Jason Whitehead from Political Science and have him open with some of the things that he's been thinking about.
Thank you. I think a lot about those modalities, because one of the things that I did before I became a professor was I was actually working in the court system. I was a clerk for a state appellate court, and then I also worked as a staff attorney for a federal court here in Los Angeles. And when I came back to the practice or the study of political science, I got my undergraduate degree in poli-sci. And when I came back to poli-sci as a graduate student after several years as an attorney, I wanted to study judges and I wanted to study courts. And I looked at the research that people were producing at that time and still today, and I didn't recognize the judges that I saw in that research. I just worked for them. I was just coming from, there was a time when I was working half-time at the U.S. District Court in downtown Los Angeles and then going to school. I did my graduate work at USC, so fairly close. And I would leave the judge. I would be in conversation with the judge that I was working with. I would come to school and talk about the research on judges, and there was a mismatch. I just didn't recognize the ideological tenor of the research that was being done on judges and that was being done on courts. So I started doing research in this as a graduate student, eventually wrote my dissertation on it, eventually published a book on it. And one of the things that I'm convinced of when we talk about these modalities is they are indeed political and ideological, but we have a misunderstanding of what the word political means. We think political really means partisan. We think it means the same thing as it does when you're talking about a politician, when you're talking about a representative in Congress, when you're talking about a president. And there are similarities. But the main difference when we're dealing with a court system, and this leads into the way that the current Supreme Court is sort of changing these norms, the main difference with regard to the way courts deliberate about decisions is you've got to get agreement among these, at least 5 of these 9 justices at the U.S. Supreme Court, and you've got to explain your reasoning. There's no other branch of government that has to explain its reasoning. Some do. The president often will have his press secretary explain something, or someone else sort of release something to the press about why they're doing what they're doing. Congress may have hearings where people talk about why they're debating and voting on certain bills, but it's only the court system that has an obligation, a kind of self-imposed obligation to explain in writing in ways that are logical and sort of connect up to other decisions that have been made by the court, to explain its reasoning, to explain how it got from here to there. So one thing about the ideology of the court and how it affects the modalities that Dr. Johnson talked about is the way in which the court is fixated on its own mission as an interpreter of law, and the way that its mission of interpreting law actually changes ideologically is that there's a different understanding among judicial conservatives and judicial liberals about the place of the court in American politics. So one of the things I'm reflecting on right now as I'm sort of studying this new court and this new conservative supermajority that we have on the court is the way in which the ideas of things like judicial restraint and judicial activism have shifted over the course of the years. If you don't know what those terms mean, judicial restraint is basically, I'll take activism first. Judicial activism is basically the position that the court should not be the primary policymakers in our federal system, that they should actually defer to legislative bodies, because legislative bodies operate in a more representative fashion. These are people elected directly by the people to actually solve their political problems. The other thing about judicial activism is the idea that sometimes when judges are making decisions, their own partisan, their own personal, social, religious, other kinds of ideas wind up affecting the decisions that they make. So judicial restraint argues that judges shouldn't do that judges should not be the primary policymakers, and that judges should not allow their personal values to play a role in their decision making. Now they do, obviously, but this is a position that says that that is essentially the wrong thing for judges to do. And then the accusation on the other side is that those judicial activists who you don't like, who are on the other side of these political divides, they're the ones that are imposing their will on you. They're the ones that are not letting the democratic process decide these policies. So we go back to, say, the 1920s and 1930s. It was liberals who were arguing in favor of judicial restraint and against judicial activism, because it was conservatives who were on the court who were blocking a lot of the progressive legislation. So it was legislation dealing with, wages and hours in the workplace. There was legislation dealing with voting. There was all kinds of legislation being proposed and being enacted, in fact, by state legislatures and by the federal legislature, especially during the New Deal in the 1930s. And the conservative Supreme Court over and over again struck down that legislation, and their interpretation of the Constitution was a fairly rigid, formalistic one. So they were using mostly the modality of text and sometimes the modality of history to say this is not, this legislation doesn't comport with our understanding of the Constitution. But over time, that comes to be viewed as a kind of judicial activism. In other words, they're taking some vague phrases in the Constitution, things like the word liberty in the 14th Amendment, or the words due process in the 14th Amendment. And they're filling those words with a meaning that's a very conservative meaning of liberty and due process. Things like, companies have a right, businesses have a right to engage in free contracts with their employees, when in fact the employees, right, may be starving, may be, at risk of getting evicted from their homes. There's no freedom on that side of the equation, but there's freedom on the company's side. And so but the court saw that as relatively equal, and in a kind of conservative way began to pull back on that progressive legislation that legislators were passing. So skip forward all the way to today's supermajority on the Supreme Court. Up until this time, throughout the 1970s and 1980s, it was conservatives who were making this argument about judicial restraint. The ideology had flipped, right, from the progressive era of the 1920s through to about the 1960s, 1970s. Once liberals got a majority on the Supreme Court, once Democratic appointees like Earl Warren and others, actually Earl Warren was a Republican appointee, but many others, liberals on the court who, Justice Brennan, for example, Justice Marshall, who took the court's doctrine in a leftward direction on things like civil rights, on things like women's rights and rights of African Americans, but also on a number of things like prisoners' rights and other things of that nature. And conservatives began to take over this idea of judicial restraint from the progressives and begin to use it themselves. Now, fast forward to today, what's happening? You're seeing another shift. You're seeing another shift where liberals are now taking back that idea of judicial restraint, arguing that judges should not be, the Supreme Court should not be the primary policymaker. It should be the democracy. It should be the representative government. What's happening, from my mind, in terms of the political science of what I see happening here, is not so much a partisan kind of shift back and forth between liberals and conservatives. They both have the same ideas. It just depends on what time and who's in power, right? So what you see ultimately is you see shifts in power when there is no democratic avenue for a political party or a movement to actually make its voice heard, or where they feel stymied by the democratic process. And this goes all the way back to the beginning of the country. In fact, the Federalist Party, the first party that we had in the United States, was the first one to pack the courts with their ideological sort of friends that would kind of preserve their ideologies from a hostile legislature. So it really depends politically on who's in control of the representative government, who's in control of Congress and the presidency, versus who's in control of the court system. And the unique thing about the court system that enables ideologies to last longer there is you've got lifetime appointments in the federal system, right, in the federal court system, not so in the presidency, not so in the Congress. So you've got a lag between the ideology of the justices that get appointed by a certain president and the existing party in power. So you get these shifts because ultimately the people in power, any group, any party, any ideology that feels like it's being locked out of power because people are voting for the other side, they retreat into the courts. They retreat into the courts because they can exert more power there for a longer period of time. It's a counter-majoritarian institution. It doesn't have to respond to the people's will. In fact, there are good reasons why courts don't respond to the people's will. But why do we see these ideological shifts? I think a lot of it has to do with the way in which the polarization of the political system right now is we're getting not only regular polarization, which is like I'm a Democrat and I don't like Republican, or I sort of lean into my Democratic ideas, and that's sort of the way I see the world. But we're also getting something called negative polarization, meaning I identify myself with who I don't like in the political process. So if I don't like Trump, then I know I'm a Democrat, I know I'm going to vote that way. If I don't like Biden, then I know I'm kind of like the opposite. And this polarization is affecting the Supreme Court as well. So what we see, in addition to those ideological shifts on judicial restraint and judicial activism, is we see shifts in the nature of the way the court does its job. So we're seeing right now a lot of polarization among the justices, where they used to get together more often, they used to conference more often together, they used to circulate opinions among one another, and that would change the nature of the opinions. And that's not happening as much, not just because of COVID, although that certainly reinforced the divisions between the justices, I think, but you're seeing the same kind of polarization that's affecting the electorate, affecting the judiciary. And so it looks from the outside to be ideological. The thing we're going to have to notice is my final thing for now. The thing that we're going to really have to notice going forward with a supermajority on the Supreme Court is the nuanced way in which different conservatives read the text differently and read the history differently and read the doctrines and precedents differently. Because Justice Thomas wing of the court is fighting for ascendancy on the court, and they don't believe in precedent. And I stated that pretty broadly, but I think it's really true. I don't think Justice Thomas really buys many of the precedents that he doesn't like. He's perfectly willing to overturn them. Others on the court do believe in precedent. Some believe in originalism in terms of the original intent of the language, as Dr. Johnson was talking about. Others actually see the original history behind the constitutional language as a kind of playing field, as something that they can use and exploit to kind of get the result that they want. So I think the difference is really between instrumental judicial decision-making that just wants to get to a certain result and doesn't really care how it gets there. And those are both liberals and conservatives historically. It doesn't really matter what ideology you have. The difference between instrumentalism and a more good faith interpretation of the text that sort of tries to take your job seriously as an interpreter of doctrine, regardless of the party that put you in power, regardless of the party that's in power in the country more generally. So those are kind of my thoughts on where we are now, where we came from, and I'm happy to kind of confer with others about the state of the court today.
All right, thank you. Should we turn it over to Amy Yamasaki? What are your thoughts as a student and what you've been thinking about in terms of the Constitution and the court today?
Those are really hard introductions to follow. I first want to say thank you for having me here. I'm honored to be next to some of the best professors that I've had. I want to talk a little bit about interpretation of the Constitution and touch on maybe the future of the Supreme Court. Forgive me if I'm looking down. I'm reading my remarks.
She's really very nervous. It's okay, and it's totally okay. I'm sure you're with her that you'd be all nervous too if you were doing the presentation. But she's really done very well in the courses and studied constitutional issues. So go for it.
Okay. So first I want to start by stating the obvious. The Constitution bears significance in many ways to many different people. The interpretation of the Constitution is also an extremely contentious issue, evident in the varying theoretical approaches by scholars, politicians, and most notably the justices on the Supreme Court. We may not be thinking about the ways in which different interpretations affect us in our everyday lives on a daily basis, but with the recent Supreme Court decisions that have shaken the nation, it is important that we don't forget the very real emotions that are also attached to interpretations of this beautiful document that was created in 1787. In my short lifetime, there have been thousands of cases heard and decided at the Supreme Court, none of which have been as significant to me as Dobbs v. Jackson Women's Health Organization. I'm sure most of you have heard about that case and have opinions and thoughts as well as I do. But I have never known a reality as a young woman in the United States without the decision of Roe v. Wade as a protection of my constitutional rights to make my own decisions about my body. I, along with many of you, have opinions, as I just said, not only on the decision itself, but on the many issues that have arisen surrounding the legitimacy of the Supreme Court. I know my generation is passionate and has had enough of the patriarchal traditions created by men throughout history, But the question is now what? What do we do? Do we pack the courts, impose term limits, use the legislative branch more strategically to codify supposed rights that are not explicit in the Constitution? How do we keep the legitimacy of the very institution that is created to set the law of the land? The institution is the last resort of the judiciary branch. I don't have an answer. I'm not sure that anybody really does at this time, but as we continue the discourse on these very real political issues, I'm hoping that there will be change as well. Change to the public's engagement with the judiciary, positive trends in civil engagement, and change to the patriarchal values that still have our country in a chokehold. Now I want to get back to the Dobbs decision, because this is the only decision that I really saw my typical, not really politically engaged friends really react to directly. And maybe we knew it was coming. Maybe we had hope that it wasn't going to happen, but it happened. And people around the country and even the world reacted emotionally. Whether you consider yourself pro-life or pro-choice, it doesn't really matter. The decision affects you. This is typical of Supreme Court decisions. Whether you care about the issue or believe it's constitutional or not, it still affects you. The interpretation of the Constitution and the rights that it guarantees, made by the 9 justices sitting on the bench, affects you. We've seen cases on religious freedom, freedom of speech, immigration, healthcare, just to name a few. All of these constitutional issues that are undeniably affected by the constant modernization and evolution of our country. Though I, and I'm sure many of you, have had anxieties about the future of women's rights, immigration, LGBTQ rights, and more, I have to say that the Constitution has provided our nation with the potential to be the best. The potential to be better, just, fair, and free for all. I believe that the Constitution can, at its best interpretations, be the foundational document for real, free, and equal society. However, to get there, it will be inevitably debated, disputed, and tried by error. I want to emphasize a point made by the late Justice Ruth Bader Ginsburg. A decision like Roe was not about women's rights, nor was it about abortion. The decision was made on the constitutional interpretation by the justices on privacy. The highly politicized nature of abortion overshadows the legitimate ruling made by the issue on privacy. I think politics overshadows a lot of the decisions as well. I bring this up to highlight the intricacies and intersection of law and politics, and how the highly politicized constitutional issues directly affect the legislative branch, judicial branch, and consequentially society. I'm so glad that we have a forum such as this one to discuss the issues of great importance on how the Constitution really plays a role in our understanding of all areas of our lives here in the United States. The founders outlined undeniable rights to us for centuries to come, and though our very young nation has a long way to go, it is up to us as citizens and humans to debate these issues, talk about them, and make sure that we really understand what's going on. So, yeah, thank you.
Thank you. So there are plenty of things that we could talk about, as we've talked about many things already today. We talk about these things amongst each other regularly on a week-by-week basis sometimes, but it does us no good to just have these conversations ongoing with us. We are interested in having a conversation with you. So do you have any questions or any comments or any thoughts about the Constitution or First Amendment or anything that we have said or that has provoked your brains in any way? Anything? Yeah.
I just thought that last thought there from Amy was really fascinating, actually, how partisan it becomes, like the actual interpretation of the court's decisions and things like that. I didn't realize because the way like us as just consumers see it, it is very politicized. These decisions are so kind of either side or. But it's actually interesting to hear how more concrete it is, how it really does try to become like a more strict interpretation, kind of document-based thing, as opposed to just like, is it a left or right issue?
Mm-hmm. Yeah.
I was just going to say a good example of that is because Dobbs is such a, it's such a monster that it's hard to kind of like see around it sometimes. It just kind of takes up all of our field of vision. But go back just a couple of years to the Bostock decision. In the Bostock decision, you had a majority opinion written by Justice Gorsuch, a Trump appointee, interpreting the Civil Rights Act. It's not a constitutional case, but it's an interpretation of a federal statute, interpreting the Civil Rights Act to protect the rights of LGBTQ Americans. It protected the right of gay employees and also transgender employees not to be fired because of their identity. And it was interesting because I think everyone would have predicted that with that conservative majority on that decision, that it would have gone the other way, if it's strictly partisan, right? So to me, that sort of highlights the idea that some of those modalities that Dr. Johnson was talking about really matter. It doesn't mean the court's not political. It just means that you oftentimes get different coalitions on the court depending on what the question is. And for a movement that wants to change, or any movement that wants to change Supreme Court doctrine, I think you've got to be really attentive, not just to the result that you want, but to how you're going to argue it to kind of get certain justices on your side. So they got Gorsuch on their side by making a strict textualist argument that it was hard for him to kind of pass up, even though the result of the decision went a way that he didn't agree with. So yeah, it's important to kind of like see that as a movement. What do you do if you want to change Supreme Court precedent? You've got to kind of pay attention to the niceties and the nuances of the law.
What I found interesting about what she was talking about was in terms of also the knowledge about the court, right? I've always found it fascinating that most people in the United States cannot name all 9 Supreme Court justices. Can any of you name all 9? Yeah, there's one person and she happens to be in my other class, right? And so they can name all 9 Supreme Court justices, right? 2/3 of the American public, according to one study that I read, 2/3 of the American public cannot name a single Supreme Court justice, and only 1% of the American public can name all 9. I've always found it really fascinating that people know that the court decided in a 5-4 opinion that this ruling came down, right? So they'll know the number of votes even. They'll say it was a 5-4 decision, but they won't be able to tell you who those 5 or who those 4 were and why that matters and how they made sense of things, right? And I find it particularly fascinating because these Supreme Court justices are on there a long time, right? It's not like needing to learn the new president of the United States. I mean, you've had since the 1991 to learn who Clarence Thomas is, right? You've had since 2003 to learn who John Roberts is, right? So 19 years you've had to learn who John Roberts is, right? You've had about that same amount of time to learn who Justice Alito is, right? Even Justice Gorsuch, you've had, what, 4 years now? About 4 years to learn who Justice Gorsuch is, right? So you have all of this time to learn who the justices are because they're on the court longer than many senators. They're certainly on there longer than many in the House of Representatives, and they're definitely on there longer than the presidents of the United States who are limited to 2 terms, right? So I think in terms of the public knowledge, I always find it fascinating that people can tell you sometimes about Congress and what they're doing, sometimes about the presidency and what they're doing. But when it comes to the 9 people that it can overrule both of those branches, who are they? Right? It's a very fascinating thing.
I think to add on to that too, I mean, just as a perspective of a student, someone who, I consider myself really busy, it's hard to keep track of everything that goes on. You don't know everything that the court hears unless you're, a scholar and studying that all the time. So the issues that we do hear about and are able to process and consume are issues that are important to the media, issues that are, more political than are, a lot of the issues that are in the Supreme Court. So I think we really care about the issues that are highly politicized, and those are the ones that we read about and see about and talk about. Yeah.
Anyone else have anything that we've thought? Yep.
I have a question for everyone. I was wondering what your thoughts are on the feasibility of the Judiciary Act and whether adding 4 seats would help with any of the current issues with the distrust in the court.
You want me to take that, or do you want to go first? All right. I think it's a tough issue, and I haven't thought through all of the complications of that kind of proposal. I'm somewhat tempted by an idea that I had where, and it came about because of the way that the Judge Garland happenings went down when Barack Obama had nominated Garland to the new seat, and then they decided not to give him a hearing and not vote on his nomination. And I just thought that, dating back to Bork, if you don't know, the liberal members of the Senate Judiciary Committee subjected Bork to an unprecedented amount of hours of questioning. Prior to that, I think that the number of hours spent were something like 6 hours. Like 6 hours you'd question a justice or a potential justice and they'd be done. And Bork was something like 45 or 60 hours or something, right? Well, that created a big tension between the parties because they're like, we've never debated the right of the president to nominate a judge before. And if the judge is fairly competent, even if you disagree with them, you confirm them. That was kind of the normal standard practice. And since then, we've had lots of heated moments in the judiciary kind of front leading up to Garland, right? Which is like I would consider kind of the apex of political maneuvering around the court, where the firepower of the parties came into a huge clash. So based on that, I thought, what if we decided that we expanded the court to 18 justices, and the current presidency got 3, the next presidency got 3, and the presidency after that got 3. That way you would have 18 justices on the court. That would result in less effect, I think, of the turnover of age. It would be harder to keep the impact of just a few members on the court serving for 30 or 40 years having as much impact as the kind of turnover of the new of the justices. So you'd have fewer presidents considering a decision based on, we need somebody who's 50 years old so they can be on the court for 30 years, right? I don't want a 65 or 70-year-old because they might not last as long, right? And so then you're getting a huge portion of the pool out of there. I think that might decrease a little bit of that. I also think that it might solve some of the partisan issues of the court. I think we'd be really surprised with 18 members of the court how few 9-9 decisions that we would get. I don't think that they would be coming down as strictly ideological. Maybe they would. And if it's a 9-9 decision, then maybe that's not so bad because that means the lower court decision stands, right? Whatever they decided, and maybe the local courts are more in tune with the local area and how they want to manage that particular issue as a matter of federal law. The only other solution that I've thought about is whether we want to entertain a mandate, and this could cause its own complications, but if we want to entertain a mandate that the current seated political party president has to nominate a judge from the circuit courts that was appointed by an opposing party president. And I think that would be a very interesting proposal because then you would find the president having to seek out a kind of more moderate-oriented judge probably, one that would be open and figuring through and thinking through the real complications of making it work for the American people. But no, I mean, none of this is solved. I mean, to speak to Professor Whitehead's distinction between judicial restraint and judicial activism, when should judges be involved and when should they not? Theoretically, they should be involved to protect against the tyranny of the majority, right? To protect the rights of minorities. And so that they should not stay out of it when the legislatures are ruling against minorities, right? On the other hand, we want to live in a democracy where the majority of the people have the ability to make decisions that would work for us. We don't want a handful of people making all of their decisions against us. That's why we don't like oligarchies in America, right? And so this tension between those two is a fundamentally irresolvable tension. Maybe it's a productive one, but I don't know. When do you think that people should ultimately be involved in protecting the rights of the minority? And when do you think? Is it just because you think so, or because the judge thinks so? Or, on what basis do we make those decisions when it comes to our constitutional interpretation? I don't know that I have a good answer to that. Those are some of my random thoughts that kind of come to mind.
I like those because those proposals are geared towards creating more moderation and towards less partisanship on the court. So the problem I have, I guess, with some of the existing proposals, including adding seats, limiting ages, things like that, is that they're responding to, it's a liberal response to a conservative majority on the court. And I'm worried that you get the same kind of arms race mentality that we had with the filibuster. So those of you who don't know, the Senate is the body that confirms federal judges. The president appoints the judge and the Senate confirms them. The Senate has this rule, this filibuster rule. It's not a constitutional rule, it's just something that they've developed over time, that they can refuse to vote on something. Used to be they had to kind of talk it out and just keep talking until the time was over. But now they can just sort of like file a piece of paper saying they're going to filibuster. So on judges, there was a period of time when George W. Bush wanted to appoint a new Supreme Court justice. There was an open seat. And the Democrats were filibustering. They came to an agreement that they wouldn't filibuster. Actually, it was lower court, circuit court judges. So they came to an agreement that we're going to get rid of the filibuster. The Republicans blew that up. And then Democrats came back when they got into power and blew up the filibuster when it came to Supreme Court nominees, which is why some of the Garland stuff happened, because you couldn't get the sort of negotiation that you would have gotten in a prior era between the senators. I guess I bring that up because I worry that any proposal you make to change the structure of the court in the moment becomes just a kind of tit for tat. So they did it to us, and so we expand by 4 seats, and then the next administration, a new Republican majority in Congress comes in and expands by another 4 seats to dilute that majority.
Or 8 to minimize it.
Or to bring it back down. Mm-hmm. So it just feels like it's, in the moment, it feels good, but it's not exactly solving the problem. It's not exactly dealing with the problem. So I like Kevin's proposals. I might also think about, I think there's some merit in the idea of blind panels. So if you had a bigger court, this is what they do on some of the circuit courts. If you had a bigger court and you didn't want like all 18 or 19 judges, however many there are, to decide those, each one of those cases, you could have a randomized process where you have a panel of, say, 5 justices who decides a particular case, and it's randomized. So you don't know if you're going to get a majority Democrat, majority Republican. It's a way to kind of like cut through, again, some of the bias and some of the ideology. But I think you got to think seriously about it and be willing to do something that might actually go against your ideology, which is not the mentality that we, unfortunately, is pervading the country right now. So
that randomized process is really interesting because it would also inhibit. So what happens a lot of times is that people who are politically motivated will try to create test cases, bringing lawsuits in front of the court intentionally because they're like, aha, I think I have the test case that will overrule this precedent. And given the Supreme Court's makeup, I know that it'll be ruled in this way if I can get it that far, right? And so you can test the case, but to your proposal, they wouldn't know. Yeah. And it could backfire if you tried to choose that case to intentionally influence it based on the politics of the court. Because if you were a liberal activist group and wanted to get your liberal majority to create it as a precedent, what happens if the conservative is drawn and then now you are not only losing the precedent, but losing that precedent potentially forever, right? So it could backfire.
Potentially.
Mm-hmm.
Do you have any opinions on putting term limits on justices? That way justices are being appointed more often.
Are you pro term limit or not?
I think there is there's a benefit to having judges on for life and not having, because I think what happens if you look at the state of California, if you look at other states that have elected judges, and they do have term limits, is two things. One is that as they near the end of the term, there are weird things that start happening with cases. It's not so much how they decide cases, it's more what they don't decide, because they're worried about political controversy. But the other thing is, it's hard to know, well, you're not asking about elections per se, but it's hard to know where to fix the term, how to get enough length in the term to where judges don't care about. I think there's a benefit in judges not caring about the majority. I know that sounds weird to say, but we were talking about it as well. Kevin was talking about how you need a court sometimes to protect minority interests, and by definition that means going against the majority usually. So in a term limit situation, I would worry that you're going to have people at the end of a term or at the beginning of a term who are even kind of trying to play politics with those cases. But now if you had a term that was not elected, that was only an appointed term for say 5-6 years, you'd then have to figure out, like, are you going to, is the appointment process going to be the same for those terms? Or are you going to have a more neutral appointment process? Because then you could have the court switching more quickly ideologically, and even the doctrines and the precedents that the court decides are going to flip a little bit more often. I don't know. I think it could be a good proposal if you added other things in to kind of qualify it in those ways. But that's just, I'm spitballing.
Do you have an opinion about term limits?
I think I'm more sympathetic to the idea of term limits than I am, packing the court or adding seats. Going back to like activist judges, judicial activism, I think the sweet spot is finding the right amount of years. I've heard 18. I read something yesterday that was about 18-year term limits, because that way it's not too influenced by campaigns and politics in general. But I think everything Dr. Whitehead said about, what are they going to do at the end of their term limit is the biggest concern, because it's not an independent judiciary if they're ruling based off of their activism or their political views. So I don't know, but I am more sympathetic to the idea of term limits for sure.
My concerns would be twofold. One is, in the wake of Citizens United, you would need to have super PACs, and the super PACs would influence with mega millions and so forth the election of judges. And that's not without historical precedent based on the way that the Copper Kings purchased federal judges in the early 1900s before any of the campaign finance regulations. So that's one thing that I would be cautious of. I'm not sure that an 18-year appointment would mean that they'd get all this money, or whatever to be elected. If they're appointed, I don't know if that solves some of it or not, because they're currently appointed. There's a check to their confirmation, so you can go through the same kind of process. But my major kind of pushback and hesitation with putting term limits on there is that I kind of believe that there is a benefit to institutional memory in some capacity, right? And I'm not saying that they should be running the whole institution forever and ever and ever, but the tenure of the court is not unlike some of the tenure rankings of professors, right? I'm a tenured professor. And one of the things that I really appreciated about being an assistant professor is that I've had professors who have been here for 30 years, who have weathered budget crises, who have been able to fight against raises and tuition hikes for students, who have known the kind of legislative political whims that have happened within legislatures to slash education budgets and be able to have things in place to be able to lobby and hedge against those things, right? If we just had a continual turnover of professors and professors and professors, we wouldn't have at least a part of our institution that remembers all of those things as part of the institutional memory. And I think the same thing might happen with the Supreme Court, right? Justices that have been there a long time remember, Clarence Thomas, for better or worse, remembers living in Jim Crow policies, right? He remembers the Persian Gulf War and serving on the court during 9/11. He remembers the national security interests. He's privy to that classified information forever and ever and ever that he's been on the court, right? He has historical reference for when we're talking about the detention of prisoners in armed conflict versus not, because he has a historical frame for all of this based on him being there and not worried about, if I make this decision, what's my next career going to be when my term ends, right? Is anybody going to hire me when I'm done with my term if I write this kind of opinion or not, right? And I'm not saying that they solve those issues, but I think that they're possibly better in some circumstances than having it all be just based on like a presidency where it, is flipped over every 4 to 8 years, or a House of Representative person who's elected to office and begins campaigning the very next day, right, for their next term, and they're like worried about that, and it's just it's a different kind of institution. And I don't think that it's perfect, but I'm also uncomfortable with the idea of term limits in that way. That's my take. Other questions? Yeah?
So I know one of the primary arguments for term limits is that there's the idea that the judges aren't sympathetic to younger generations.
Mm-hmm.
Different demographics and things, and I don't know exactly how the court system works, but like how are the judges influenced by current people's struggles that influences their decisions? Like how are other people, younger people, represented to the judges?
What do you think? The younger person. Yeah.
I don't know. I don't know how justices in general, what news they're following. I don't know how they're necessarily trying to connect with the youth, if they are at all. I think like Amy Coney Barrett is a great example of someone that's like younger, has young children. She still, in many ways, can be relatable to younger generations, but then then you look at it, are her rulings representative of, or her opinions representative of us? And I don't know. I really don't know what the younger, the new generation, our generation is really activist, I think. I think we are very passionate about a lot of issues. So it'll be interesting to see how the court does respond to that, because I think that our generation is different than many of the generations that have come before. So I think that's yet to be seen as well.
I think some justices also make a better effort than others, right? I mean, Chief Justice Roberts didn't even know what a tweet was 4 years ago or something like that, right? And then you have Justice Sotomayor, who's making appearances on Sesame Street, right? So you have differing kinds of effort that I think that they would be putting into that. I don't know that that's necessarily a term limit question, more than maybe something that the judiciary should consider in the confirmation hearing. I've never heard them talk about their influence or their thoughts about young and emerging people in the hearings. That's never really a question that they ask, right? The senators. I can't recall them ever asking, what kinds of things would you consider might be different amongst 18 to 25-year-old members of society versus ones of your generation. They don't really ask that question in the Senate Judiciary, right?
The problem is the senators are in
Right.
the same category,
Right.
of sort of
Right.
a little bit shielded
Yeah.
from youthful activism. And,
Yeah.
but there are ways in which so representation is a funny thing on the court. There have been all kinds of fights over certain seats and whether they should go to certain people based on certain demographics. There was a Jewish seat on the court for a while that kind of there was some pressure that there was only one Jewish justice on the court, and when that person went away, they wanted to replace and did replace it with another Jewish person. There was a talk about how many women should be on the court to represent the broad sort of cross-section of gender in the United States, but also race and things like that. But that representation is more in terms of individuals who get put into that position that are meant to sort of, in some way, reflect like the diversity of the country, but it doesn't, it's a really imprecise measure, obviously, of, because Amy Coney Barrett is is she the youngest?
I think she is, yes.
And a woman, and yet would not, if you looked at sort of the positions that she takes versus the positions of sort of the median woman voter, like 18 to 24-year-old voter, she doesn't match up, right? So it's a really imprecise way to do that representation. But the other thing is, like, I'm not sure I'm comfortable with the idea of talking about the court representing a particular group, because their job is really to, sometimes their job would be to vote against that group if the law sort of went in that direction. I'm a romantic when it comes to this kind of stuff about law, because I think that it's easy to say, I want justices to do what to get to the result that my generation wants, or that my group wants, or my party wants. It's another thing to say, we have a rule book, and it's not a precise rule book, but we've got to kind of like document that is supposed to guide us. And if we're not being guided by that document, if we're guided instead by our view of like how it ought to be interpreted to get the result that I want, then it becomes a kind of slot machine sort of justice. And when that goes against you, you look at it in the news and you go, that's not a rule of law system. That's not the kind of system that I want. I don't want justices ignoring the law to reach a particular result that might favor young people, might favor women, or might favor anyone in society. The problem is that it does already, right? So, like, there's a lot of instrumentalism on the court in favor of elite, wealthy, white, take your pick of the ruling class in America. And you've got so many decisions that seem to kind of favor their interest. So it's hard not to be cynical about that. But I kind of hold back when we talk about representation on the court, because I want it to be aloof. And I want it to just interpret the law, even though it doesn't always.
So I'd like to thank you for joining the Constitution Day talk today. I'd like to thank Professor Ann Johnson for having us as a guest in class today. Thank you so much. Thank you to our panelists. And I hope that the viewers at home have learned something about Constitution issues on Constitution Day. Bye-bye.